Court. My name is Casey DeVos, and I represent the state of Washington. I would like to reserve 1 minute for rebuttal. I'm here today to ask the Court to grant the state's motion to omit all evidence of financial dealings seized by law enforcement officers during the search of the defendant's home and car on March 7, 2007. On March 7, 2007, Lakewood police officers served a search warrant on the defendant's residence. During the search, the officers located numerous documents and several briefcases or backpacks in the defendant's home and car. These documents are the state's evidence. The documents include blank checks, credit cards, financial mail, and financial mail which had social security numbers and credit card numbers on them. Within this evidence, there is a portion that has been contested. The contested evidence are tools of the identity theft trade. They include blank laminating cards, blank forms, a social security database, half-filled visa applications, and various other tools that were used by the defendant to commit the crime of identity theft. Under Evidence Rule 404B, the state will request that the court admit evidence. Under this evidence rule, the court may admit evidence when it is to prove intent, to prove knowledge, and under the res geste exception. Under these three elements, the state requests the court to admit this evidence.
What's the state's burden here, counsel?
The state's burden is to show that the evidence is probative and necessary for the various exceptions to Rule 404B. For example, in the first issue that the state is requesting the court admit evidence on intent, whenever intent is at issue in a case, the court may admit evidence to prove intent. In this instance, intent is at issue in the case because one, it is an element of the charged crime, and two, it is at issue in the case, and it may be admissible to rebut any claims of mistake or accident.
Counsel, you mentioned that there were some blank forms in the evidence that the state seeks to admit. How do these blank forms establish intent?
Well, we're admitting the intent evidence for the reason that for 4 of the victims, we have not been able to contact them. In the instance of these 4 victims, we've not been able to achieve a testimony from them to show that their financial information was obtained fraudulently, that they did not give permission to the defendant to use the financial information, and we cannot ascertain the gravity of the harm that happened to these 4 victims. We need the state needs the evidence of the blank forms and the laminating material and the half-filled out social security information to show that not only did the defendant have these victims' information, but he had a systematic process in which he was taking this information, applying for a Visa card, and subsequently defrauding the various victims in the case. So in that way, we have to show that he has an intent to commit the crime, as it says in the statute. And as it is an element of the statute, the state contends that it is necessary and probative to that end. Along the same lines, the state requires this evidence to show, and it is necessary to show knowledge on the part of the defendant. Whenever knowledge is at issue in a case, the state may admit evidence to show that to prove that element of the crime. In the identity theft statute, the defendant must have knowledge of knowingly possess or use the evidence with the intent to commit a crime. We need this evidence to show that knowledge. In situations where the committed crime is perhaps stolen material or illegal material, the court has readily allowed evidence of prior bad acts to show that the defendant had knowledge of his possession. For example, in State v. Wells, the court allowed evidence of drug paraphernalia to be submitted as evidence to prove that the defendant had knowledge of the drugs that were found in the defendant's home. In this instance, we have multiple pieces of identity theft paraphernalia that the state will submit to show that the defendant had knowledge that the identification he had obtained was fraudulently obtained and used and illegally obtained. finally, the state requests that the evidence be admitted to allow the state to present the full picture of identity theft to the jury. Under the res geste exception, the state must be allowed to show the entire story of identity theft. Identity theft is by no means a simple crime. To go from not having someone's identity to obtaining someone's identity and subsequently defrauding them through applying for credit cards, there are multiple steps and a very long process. The state needs to be able to show all steps of that process, or else the jury will be left with a fragmented picture.
But counsel, if the jury can't, I mean, there are numerous charged counts here and evidence going to those charges, correct?
Correct.
So if the jury can't get a complete picture of what's going on here already with respect to all the other charged counts and the evidence that goes to those charged counts, how is this evidence going to complete that story? I mean, the story seems complete.
Okay. In some instances, the story does seem complete. However, for other instances, it is not. It is by no means complete. In the instances where we have not been able to contact the victims, those are specific instances where the story is not complete. In general, for example, if we take the situation where we have the most evidence, Mr. Moses Thayer, we have an identity card with the defendant's picture on it, but Moses Thayer's identification. However, we have no means of showing how the defendant was able to acquire this information. And to be able to present the jury the best evidence and to be able to meet our burden of proof of beyond a reasonable doubt, the state should be able to present that entire picture. In State v. Lillard, the court said a defendant cannot insulate himself by committing a string of connected offenses and then argue that the evidence of other uncharged crimes is inadmissible because it shows the defendant's bad character. In the same light, the state should not be required to show a fragmented pieces of the events that happened and the events of the identity theft because the defendant is going to claim that it goes to his bad character.
Counsel, I can only allow admission of this evidence on the res geste, under the res geste exception if it's in the immediate context of other evidence. So what is the immediacy here?
Immediate context. The immediate context is that we have a series of events that culminate in the defrauding of the victim. And to prove the immediate defrauding of the victim, we have to go through this series of events. So we have to show that the defendant acquired the person's identification, that they had the Social Security database, that they applied for the Social Security number, subsequently got the visa, and were able to show, and finally to show their defrauding. I want to end with this conclusion. The defense is going to argue that this is prejudicial, and they're going to argue that it's duplicative and that it is going to elicit an emotional response from the jury. The state has showed specific instances of where we need the evidence to show. It has shown specific instances of where we need the evidence to show issues that are lying open in the case. Under the intent and under the knowledge justifications, we need this evidence to show it. It's a purely probative value, and we're not using the evidence to elicit any kind of inference of bad character. This evidence is very similar to many other cases where the court has allowed evidence of bad acts. For example, in the drug paraphernalia case, or in the case of State v. Harrison, where the court allowed multiple elements of fraudulent checks to uncharged fraudulent checks for the purposes of proving fraud.
Thank you. And you've reserved 1 minute of rebuttal.
Yes.
I'm ready to hear from defense counsel.